In this CVM News update, Wisynco has been acquitted of charges it breached the Wildlife Protection Act. The matter, which was brought to a close on Monday, would have been a year old in October. Curlin Brown sought further clarity from the Director of Public Prosecutions, DPP, Paula Llewellyn.
So it's case closed.
Case closed. Let us leave it at that.
The conclusion to a case first brought before the St. Catherine Parish Court in October 2024 against Wisynco Limited regarding the alleged breach of Section 11 of the Wildlife Protection Act. The charge resulted from a matter which surfaced when the National Environment and Planning Agency, NEPA, responded to reports of a pipeline leakage into the Rio Cobre, also in St. Catherine, and the discovery of dead fish on the bank of the river. A disparity arose after a review leading to the conclusion by the Office of the Director of Public Prosecution the Crown did not have a viable case. The Act states, notwithstanding anything to the contrary, every person who causes or knowingly permits to flow or puts or knowingly permits to be put, whether directly or indirectly, into any harbor, river, stream, canal, lagoon or estuary containing fish, any trade effluent or industrial waste or sewage or noxious or polluting matter shall be guilty of an offence against this section and shall, upon conviction before a parish judge, be liable to a fine not exceeding $100,000 or to imprisonment for a term not exceeding 2 years or both such fine and imprisonment.
In terms of our review, we found that no samples of water had been taken by NEPA from the river beneath where the fluid had been seen gushing into the river from the pipeline which went from Wisynco on one side of the river to the other side of the river. So we were not in a position to prove that this was trade effluent or industrial waste or sewage or noxious or polluting matter.
Bluntly put, the substance was not scientifically identified as a matter of law, as a substance capable or falling within the definition of those listed under the Act. Additionally, the NEPA officers admitting to forming a view the company was unaware the pipeline was leaking fluid into the river. The DPP further explains the prosecution was not in a position to evidentially prove the character and nature.
You can't make assumptions, you can't use suspicion, and you can't speculate. That is way below the standard required to prove a case.
The DPP stresses this is a teachable moment for all.
Because guess what? It is in the public interest that there is robust adherence to the laws when it comes to making sure that we don't have these environmental breaches. And if you have environmental breaches, that there is accountability. Accountability through the courts, or it helps to cause these companies to say prevention is better than cure.
Curlin Brown, CVM News.